Hello everyone, just a quick video about a question I get asked all the time when I work with single parents. If something happens to me, the single parent, if I become unable to care for my kids because let's say I was in a car accident or I became incapacitated for whatever reason, or if the single parent die, will the other parent automatically receive sole custody of the kids? The answer is it depends. Each situation is so unique and it has its own facts, so I cannot give you a straight yes or no answer. What I can tell you though is that it's always good to have a plan in place. So what does it mean to have a plan in place? Well, first of all, talk to a person of your choosing about becoming a potential guardian for your kids. It is important that someone will step up if something happens to you to try and care for your kids, especially if the other parent is not able, willing, or suitable to do so. More so, be sure to have something in writing, because if something were to happen to you, it'll be very important for a judge to have something in writing, signed and notarized, that says, hey, this is what I want to happen to my kids. What I also recommend when I meet with people whom ex-spouse or the other parent of the kids is not an appropriate parent is have a little folder and give it to your potential guardian and say, hey, if something happens to me, please be sure that the judge sees the information in this folder. Unless the other parent has a criminal record, a judge wouldn't know that the other parent has a drinking problem or they're violent, and they wouldn't make for a fit parent. So what can you do now to ensure, or at least to increase the chances that the people you choose will be in charge of your children, and more so that the people you choose will be in charge of your finances if you become incapacitated, or of the children's inheritance if you die? We have a power of attorney and a will, and both of those documents we include what it's called a minor child guardianship designation, in which you specifically tell the courts, I want this person and this person or this person to serve as a guardian. And sometimes we even put, I specifically do not want, let's say, the other parent or my sibling to be in charge of my children. Because like I said, unless there is something, a record somewhere, the judge wouldn't know your family dynamics. In addition, you can use a revocable trust to ensure that the people you nominate, the trustee, will manage the funds, but also where you can provide for a gradual distribution for your kids, as in for them to receive certain amounts at certain times, certain ages, or certain life events. To summarize, there is no clear answer whether the other parent will automatically become the sole caregiver for your kids. But as we talked about, you can make it more likely that the people you choose, the people you trust, will have a role, would have a say in who raises your kids and on how the funds you may leave behind for them will be spent. So please give us a call, 405-857-8231, if you have any questions about this video or if you want to talk more about your specific set of circumstances. Thank you for watching.